All right, so welcome officially to this second in a series of three webinars for local authorities on education law. Today's webinar is entitled Exclusions, Reflections and Case Law Updates. I'm Ben Amunwa. I'm a barrister at Three Paper Buildings, specialising in education, employment and public law. And I'm joined by my colleague, who I'll let introduce himself.
Hello, everybody. My name's Lachlan Wilson. I've been an education law practitioner for in excess of 25 years, far too long that I can recollect accurately. But I also practice in employment law. And there is an obvious connection between the two, mainly in the areas of discriminatory law, which is what I'm going to be presenting, focusing on today, because we understand it to be a prime concern for when exclusions happen for behaviour reasons that may be linked to SEN or disability. Thank you, Ben.
Thanks, Lachlan. And we also have with us our marketing manager, Delphine Avondo, who's been helping in the background to facilitate this webinar. So both Lachlan and I are very grateful to her for her assistance today. All right, so as I said, this is part of a three-part series. I should say before we get underway that the third part is coming up on the 19th of November. So please do, if you haven't already, block out your diaries for the same time, 11 a.m. on the 19th of November to hear about avoiding and defending judicial review, which I'm sure will be of considerable interest to many of you. And that will be provided by Catherine Anderson and Jim Hirschman, both members of the education law team at 3PB. A further plug, if you'll forgive me for this, for our upcoming educational law conference, an annual conference, that's coming up on the 5th of February 2026. So please do mark your diary and get in touch with us if you'd like to know more about that. Okay, with that preamble out of the way, let's get into the session. And we'll aim to finish by midday. So here's a very quick outline of what we're covering, a bit of context, the legal framework, because I think it's important that before we dive into the case law, we've got a bit of a grounding and a recap of the legal landscape. And then after we've discussed some cases and principles underlying them, there'll also be a chance to sweep up with Q&A. So the context. Well, it's perhaps no surprise that so many of you are joining us today, because in terms of the numbers, when I had a look at the most recent data available on the government website for exclusions in England, the data suggests that there has been significant rises in both the number of exclusions and also the rate of exclusions per 100 pupil. You can explore that data further at the link that I've put on this slide at the bottom. And that fits with the overall trend over the last decade or so of official statistics. It's been effectively a year-on-year rise, albeit with a slight dip reflecting the different arrangements during the pandemic. But another feature of the data, which is perhaps of significant concern for us today, and which is reflected in some of the cases that we'll be discussing, is that the data demonstrates that pupils with certain characteristics are at a higher risk of exclusion, including suspension and permanent exclusion. Those characteristics include, for example, eligibility for free school meals as an indicator of social deprivation, special educational needs, and also various protected characteristics in terms of race and ethnicity, Gypsy, Roma, and traveller of Irish heritage children, children who are mixed white and black Caribbean, and children who are of black Caribbean ethnicity. And in fact, the statistics reflect that pretty much in that order, they are at higher risk. So the highest risk in terms of statistics Gypsy and Roma, followed by traveller of Irish heritage, followed by mixed white and black Caribbean and black Caribbean. And I think it's also worth kind of reminding ourselves of the reality behind the data. Of course, behind these labels and statistics are children, ultimately. And it's important not to lose sight of that. Another trend that has been broadly acknowledged in the context is that exclusion has been linked to poorer life outcomes later in life and to increased risk of criminality and gang violence. And that's via various government reviews from 2019 and onwards. So, the legal framework, very briefly, before one even gets to exclusion, i.e. suspension or permanent exclusion, there are a range of powers for disciplinary powers, essentially, in schools. It's not a topic which we're going to be discussing today in any depth, but I've just flagged it here for your attention so that you know where to find the law and you know where to find a recent case, the Gorse Academies Trust case, which discusses that legal framework and how it interacts with human rights law under Article 8 of the European Convention. So I'll just bring that to your attention, but swiftly move forward. The power to exclude rests with the head teacher in the context of maintained schools in England. And primarily, we are looking at the following provisions: Section 51A of the Education Act 2002, so that's the primary legislation as amended. The regulations, School Discipline, Pupil Exclusions and Reviews, England Regulations 2012, so for short, the 2012 regulations, and the statutory guidance that accompanies this framework. Again, I won't read out the full title because it's quite wordy. I will just refer to it as the guidance for the purposes of today. There are separate provisions for Wales. But that isn't the whole story, because there's a much wider legal landscape which includes further regulations and further guidance from government aimed at specific aspects that interact with exclusion. We won't go through it all today, but it's on the slides for your reference. Types of exclusions, I've highlighted here that we've got permanent exclusions, PECs for short, where the pupil is no longer allowed to attend unless they're reinstated. And then there's fixed period exclusions, or sometimes called fixed term exclusions. We just refer to those as FPEs for today. And those exclusions with a defined end date that's fixed when they're first imposed. And there's separate detailed rules about how many days FPEs can be used for. And I've just popped those in this slide below. In terms of the process then, in maintained schools for permanent exclusions, or PECs, in England, there are essentially up to 4 stages that we need to have in mind. Stage 1, as I've shown here, is the head teacher's PECs decision, and you've got the provisions that apply there. And I'll go into that in a bit more detail in a moment as to the test that the head teacher is to apply. Once that decision is made, stage 2 comes into play, where the governing board of the school has to bring together a Governor's Disciplinary Committee, or GDC, to decide whether to reinstate the pupil that the head teacher has subject to PECs. And that is essentially an evaluative review of the head teacher's decision for its legality, rationality, procedural fairness, and compliance with the law. If the GDC at stage 2 decides not to reinstate the pupil, then the pupil, if they're 18 or over, or their parent or carer, can request an independent review by an independent review panel, IRP for short. Again, you've got the various provisions that interact with that and which provide guidance on the task of the IRP, which we'll be thinking about a bit more today. The IRP has the power to firstly uphold the decision of the GDC at stage 2, or it has the power to recommend that the GDC reconsider whether or not to reinstate the pupil. And that will tend to come into play where the IRP has concerns around the legality, rationality, or fairness of the decision. Or they have the power to quash the GDC stage 2 decision and to direct that the GDC reconsider its decision on reinstatement. And if they do exercise the power to quash, the sort of highest power that it has, the IRP has a further power to impose a budget adjustment of £4,000 on the school should the GDC fail to reinstate the pupil after reconsideration at stage 4. So GDC reconsideration is the last stage that we see there, and that will follow if the IRP has concerns about the GDC decision at stage 2, or if it quashes the decision at GDC stage 2. And just standing back for a moment, I mean, you can see here that the full process, stages 1 to 4, incorporate essentially 4 evaluative judgments. And then once you add in the possibility of a judicial review by the High Court of the decision at stage 3 or the decision at stage 4, or even both, you've then got a further sort of 5th layer of review that interacts with all of this. It is a recipe for some complexity. Going into a bit more detail and thinking about the stage 1 decision by the head teacher as to whether or not to permanently exclude a pupil from a maintained school, what the guidance tells us is that the head teacher needs to apply what's known as a twofold test. And that is to consider, well, first of all, that a PECS should be a measure of last resort. So has the school done everything it reasonably can to avoid this last resort of PECS? And then there are 2 broad criteria that must be met in all cases of PECS, and that is that there is a serious breach or persistent breaches of a school's behaviour policy, and where allowing the pupil to remain in school would seriously harm the education or welfare of the pupil or others in the school. But that's not the end of the analysis. In many ways, that is perhaps just halfway, because in all cases, even if both limbs of the twofold test are satisfied, so you've got either serious breach or persistent breaches, plus a serious risk of harm to the pupil or others if the pupil remains, PECS must nevertheless be appropriate and proportionate overall. So the twofold test has very much been characterized as a minimum threshold, and that's from the case of TZA and a secondary school. That's a Court of Appeal case from earlier this year, which I'll talk about in a few moments as well. At all stages, so there are some themes that carry across all 4 of the stages. The head teacher, the GDC, the local authority, and the IRP must consider the guidance, that is the statutory guidance that I've referred to. The standard of proof is on balance of probabilities. So if there are disputes of fact around the incident that has led to the PECS, that must be decided in terms of what is more likely than not to have happened. There must be compliance in relation to the Children and Families Act 2014, which is something that Lachlan will return to. And also there must be compliance with equalities and human rights obligations. But what are those obligations, and how are they managed? That brings me to the next slide, which just sets out in a bit more detail the equalities obligations. So we're looking particularly at Part 6 of the Equality Act, which essentially takes the prohibitions in Part 2. So Part 2 sort of defines, if you like, in the abstract, what direct discrimination is, indirect discrimination, breach of duty of reasonable adjustments, victimization, harassment, defines all of those terms. And then Part 6 applies them to schools and the education sector. Part 11 of the Equality Act contains the public sector equality duty. And that's an important duty which many of you will be very familiar with, I'm sure, or at least have some familiarity with if you've been involved in public law litigation. Arose in the aftermath of the murder of Stephen Lawrence and the botched investigation into that incident. And essentially, it is where the law requires public bodies and decision makers to have due regard to 3 equalities objectives. I've listed the 3 equalities objectives there. They are broadly worded, and there is quite a lot of case law exploring what they mean. We'll come back to that when we look at TZA. In terms of human rights obligations, Section 6 requires compatibility with the ECHR by public authorities, and I've just listed a short list of relevant or particularly relevant articles of the European Convention on Human Rights. I've in particular highlighted Article 4, which is the absolute right to freedom from slavery, servitude, or forced or compulsory labor. Now, that might seem a little bit off the wall in this context, but all will become clear when we look at the case law in about 2 slides' time. I've listed also Article 6, the qualified right to a fair trial, Article 8, right to private and family life, 9, freedom of thought, conscience and religion, 14, freedom from discrimination, and Article 2 of Protocol 1, right to education. There are even further responsibilities on local authorities, and I've listed some of them here. The local authorities obviously arrange the IRP meetings and hearings in the context of maintained schools, not for academies, but maintained schools. And that means bringing them together, arranging the clerking, training, and indeed paying for them, plus indemnifying them against legal risk as well. Then there is provision for the local authority to attend the Stage 2 GDC meetings, and also for a social worker to attend IRP meetings. This is really important, and you'll see why in a moment by reference to the case law. Legal advice, representation to both the governing body and also IRPs. That is an interesting feature of this arrangement, because obviously an IRP is supposed to be independent, and in fact is independent from the school. However, it is convened by the local authority, and the local authority will tend to provide the legal representation upon a judicial review challenge against it. LGO complaints are also something that you'll be dealing with, and of course, the duties to provide alternative provision. So I hope you'll forgive me for that pretty much gallop through the legal framework, but I hope one thing that it illustrates is just how broad it is. There's quite a lot of moving parts to it, and this is, of course, just a summary. To the case law. And again, forgive me for condensing this somewhat, but the first 3 cases that I want to tell you about are, in fact, Article 4 cases, cases which raised the European Convention on Human Rights, Article 4, right to be free from slavery, forced labor, and servitude. And these arose in the context of child criminal exploitation. So roughly speaking, I'm going to take them in order, in descending order of merit. So we're going to start with the stronger case, which is NAA. I've labeled this one a cautionary tale. It really is. Unfortunately, the local authority representative who attended at the stage 2 GDC in this case did not share key information with the school and the GDC, and nor did the local authority make a key referral. The upshot was a breach of Article 4 of the ECHR, plus a breach of the local authority's statutory duty to refer modern slavery cases to the Home Office. So what happened? This is a judicial review following PECs of a Year 10 pupil for supplying drugs and making violent threats. The IRP actually upheld this PECs. The local authority was aware of CCE, or child criminal exploitation, indications prior to the incident that led to the PECs due to its referrals and risk assessments. And after the incident that led to the PECs, the police arrested the child, but upon arrest, they made a referral to the Home Office under what's called the National Referral Mechanism, the NRM, which is essentially the main way in which the UK discharges its obligation to identify victims of modern slavery. The NRM found reasonable grounds to suspect that the child was a victim of modern slavery or forced labour, and we call that the positive RG decision, reasonable grounds decision. So the local authority, coming into the PECs process, knew about both the NRM referral and the positive RG decision, but they didn't share that with the school or GDC. And you can see, just thinking back about the questions and the evaluation throughout the stages of the PECs process, how if you're missing a pretty vital piece of relevant information, that can result in a breach and an unlawful process. So Judge Ward held the LA in breach. And in terms of the duty under Article 4, because Article 4 is an absolute right, there's a positive duty to protect, take steps, reasonable steps to protect from the risk of exploitation, re-trafficking. But the LA had failed to meet that test, failed to discharge that positive obligation. However, the one point that I suppose went in the favour of the local authority was that the court declined to award damages. And that's because essentially the child had only suffered the loss of a chance that the stage 2 decision might have been different. It was unlikely that it would have been. So a declaration awarded by the High Court, but no damages. It might be something to keep in mind in terms of settling these types of cases. Very quickly then descending into the next rung of merit. So this was a weaker case, a case known as RWU, started in the High Court last year, ended up in the Court of Appeal this year. And this looked at the question of when the Article 4 duty to protect is triggered. Again, brief summary there. You can read that in your own time because I'll need to be swift. Essentially, what the court clarified, the third bullet on the slide, is that for the positive duty to protect under Article 4 to be triggered, the question is whether the Academy was aware or ought to be aware of circumstances giving rise to a credible suspicion of a real and immediate risk of having been or being trafficked or exploited. It's quite a demanding test under Article 4 when you're thinking about positive duties. And here the test wasn't met. And that's because neither the local authority nor the police, who are both in the lingo designated first responders under the NRM, neither of them formed the view that the NRM threshold was met at the time of the GDC stage 4 decision. Subsequently, so after stage 4, the NRM did actually make a positive finding that RWU was suspected to be a victim of modern slavery, but that was too late. The process under the PECs had completed. No breach. And there's some further guidance from the Court of Appeal. I'll let you digest that subsequently. CM, the weaker case of the pack of 3 Article 4 cases to update you on. Again, I'll let you read that, but highly vulnerable child, exceptionally vulnerable, previously looked after with SEN, had been the victim of sexual assaults, as she reported, and was subject to PECs following persistent breaches. The school were aware of indicators of child sexual exploitation among other vulnerabilities. However, there was no NRM referral either before or after the PECs. And ultimately, the court found that there wasn't evidence before the school, the GDC, or the IRP of any risk of recruitment into, as the claimants highlighted, county lines drug trafficking. So that case did not result in a finding against the local authority or the IRP. Last case, and very briefly, the thing to highlight about TZA, I've already touched on it. This is an important case. I would very much commend Lord Justice Underhill's judgment to you all. Please read it in full. It's very informative across the 4 stages. Something it does highlight, though, for our purposes, is the importance of the process plugging gaps in earlier stages. So the head teacher's PECS decision, in this case, as I put on the second bullet, did not specifically consider the PSED, the public sector equality duty. The PECS was upheld by the GDC, the IRP recommended reconsideration, the GDC declined to reinstate. At the GDC Stage 2 meeting, the local authority representative highlighted various data and information around TZB, the child in this case, having high-risk characteristics for exclusion. This was a Black Caribbean child with SEN. And that was the right thing to do, and a positive contribution by the local authority, which helped to steer, in my analysis, the GDC's consideration and effectively to plug a significant gap in the head teacher's PECS decision. So this case does underscore both the important role of the LA representative at that stage, but also the fact that the GDC is the ultimate decision maker as part of that sort of stage 1 and stage 2 being seen as a connected process. The GDC ultimately have more information than the head teacher and ultimately decide on the legality and rationality of the PECS decision by the head teacher. So you can explore TZA and what I've got to say about it in more detail with the slides afterwards. I've put a key point summary at the end of my section, which just tries to weave together some of the Article 4 points. That's the first, that's the second, the third and fourth bullet, and the first and the second bullet are discussing how the LA interacts with the 4 stages that I've just outlined. So forgive me for galloping through much of that. I'm now going to hand over to Lachlan Wilson, who will talk to you about specific factors on special education needs and disabilities. Unless, Lachlan, there are any questions that have arrived through the Q&A which you'd like me to try and deal with.
Well, to be fair to you, Ben, and thank you for that, Ben, there are 3 questions, and I do think we should deal with them now, but I've had the benefit of reading them, you haven't. So let me begin with the first one that I think we can deal with relatively speedily. How does this all apply, that's the legislative framework, to independent special schools? And I think I can deal with that briefly by saying it doesn't, because the guidance only applies to the maintained sector, but independent special schools are not out with their requirements under the Equality Act. And of course, I will be touching on that. I don't know if you want to add anything more to that answer, Ben.
No, I think that's fairly clear, Lachlan. Thank you.
Excellent. The next question is, how do you reconcile the requirement not to send pupils home for a cooling off period and the need to investigate matters, and the guidance which suggests that a fixed term exclusion should not, other than in exceptional circumstances, be converted into a permanent exclusion? And again, I've had the benefit of giving that question some thought. And it is really a question that very much will turn on its own facts. Uh, The requirement to send pupils home is, first of all, the first question to ask in those circumstances. Why do you need to send the pupil home in order to investigate matters? Is it impossible to investigate matters while the pupil is still in attendance? No problem with the pupil being in attendance in isolation or in a room, perhaps with other staff present. So the question is, what is the need to send the pupil home? And of course, that will turn on its facts. If you are sending the pupil home, you are effectively giving a fixed term exclusion. You do need to consider whether you should be doing that, whether the threshold has been met for that. But if it has been met for that, so be it. What are the exceptional circumstances? Well, it's the new material found in the course of your investigation. But your fixed term exclusion should only be given on the material that you've already got. So you should already have undertaken some investigation before sending the pupil home. And of course, there is a categoric right that the pupil concerned needs the opportunity to answer to his conduct. So I hope that has helped. It doesn't reconcile, but my concern in the question is maybe there is an alacrity to jump towards sending the pupil home in order to carry out investigations, for which I am advocating caution. Ben, I don't know if you, having heard all that, want to add anything.
Yeah, no, I would echo that cautious approach. Clearly, there can be exceptional circumstances where a PEX can follow a fixed period exclusion, but the guidance is fairly clear that it's an exceptional threshold, so it's kind of limited to those types of circumstances. And I think LAs and their school partners need to be vigilant for effectively these sorts of invisible or undocumented forms of exclusion, which can obviously infringe rights to education and also other rights in the context of SCN as well.
Thank you, Ben. And finally, well, I say finally, there are four questions, in fact, as I understand it. But the next question is, where the IRP quashes a governing board's, that must be decision, the IRP should order that a readjustment is made. So highlighting the language in paragraph 231 of the guidance. And the question is, what circumstances would the IRP not order a readjustment following a quashing? I've not come across one. I've always, in the rare quashings that take place, have always had the adjustment also ordered. I don't know if you have a different experience, Ben.
Yeah, it's interesting. I mean, I think kind of goes back to that distinction between linguistic distinction between should and must in statutory guidance. So there's clearly a measure of discretion in terms of ordering that the budget adjustment should apply. I think there is a broader question, and sorry to be slightly evasive here, but there's a broader question around the extent to which IRPs provide reasons for and explain their exercise of discretion, because something that I've come across quite often is IRPs being criticised or challenged on the basis that they should have quashed or they shouldn't have just recommended reconsideration, and also that they haven't properly explained how or why they've exercised their discretion in one way or another. And so I think that does highlight a real sort of area of training need, or an area where IRPs could benefit from more clarity. And again, that same sort of discretionary exercise would apply to, I think, the power to order the budget adjustment as well.
Thanks for that, Ben. One other question that's just come in is, are the governing body automatically obliged to convene a GDC, or does that only happen if parent appeals the head's decision?
Yeah, it's automatic, isn't it? They must they must consider reinstatement upon PECs. Yeah.
Thank you, Ben. And I think that is all the questions so far answered in the Q&A. Do continue to put questions in the Q&A, and no doubt there will be many that flow from my presentation. If we could move on to the next slide, please, Ben. So I'm going to begin with the definition of special educational needs, because it is the case that predominantly most behavioural issues will arise from special educational needs. We have to go to the Children and Families Act 2014 for the definition. A child has SEN, special educational needs, a child or young person, that's why it's CYP there, if they have a learning difficulty or disability which calls for special educational provision. Special educational provision is educational or training provision that's additional to or different from that generally made for others of the same age in mainstream provision. And of course, when it comes to behavioural issues, there is likely to be learning needs that focus on sensory regulation, the ability to control and self-regulate behaviours is likely to arise. Local authorities and governing bodies, academy proprietors, management committees, that's if we are dealing with pupil referral units, have duties to cooperate with each other. And schools need to consider whether an education, health and care plan is required as the practical means to secure the provision which the child or young person requires. And if so, request an assessment from the local authority. And governing bodies must use best endeavours to secure that the SEP called for by the specific pupil's SEN is provided. Now, that is a whistle-stop tour. This webinar is not intended to be a webinar on special educational needs and provision to meet those needs. But the reason why I flag it up right at the outset is because the primary consideration will be behaviours that are likely to arise from special educational needs. We can move on to the next slide. See here where I want to link the definition with disability. So we all know that the definition of disability under the Equality Act is a person has a disability if she has a physical and mental impairment which has a substantial and long-term adverse effect on their ability to carry out normal day-to-day activities. And you're enjoined there to look at Schedule 1 of the Equality Act and the statutory guidance that's listed there. Now, it's right that not all special educational needs will constitute disabilities within the definition of the Equality Act. But if we have a child with SEN, and I've written here, such that an EHCP has been considered necessary, it's likely to satisfy this test. And the special educational provision set down in the plan at section F is likely to constitute, or certainly give definition for, or inform what are reasonable adjustments. Now, I'm suggesting an air of caution there. Even if the child does not have an EHCP, it is quite possible that they have been identified as having special educational needs that the school may or may not have considered is capable of being met within the school's ordinary special educational need provision, but who will also, as a result of those needs, fit the definition of disability under the Equality Act. And so it is not that an EHCP will get the child into the definition of equality. It is what are the child's learning needs. Move on to the next slide. I'll whistle through these because Ben has touched upon them, but we've got the prohibited treatment under the Equality Act, direct discrimination, indirect discrimination arising, failure to make reasonable adjustments, pregnancy and maternity, harassment and victimization. Now, all the ones that I've highlighted in bold are the ones that I will be addressing because they are principally the ones that arise in disability cases that concern IRPs. So we're going to look at section 13, we're going to look at section 15, and we're going to look at failure to make reasonable adjustments. Direct discrimination is when a person A treats person B less favorably than another person. The critical thing here is there must be no material difference between the circumstances of person B and the comparator. And the key issue generally is whether the less favorable treatment is because of the disability. And ultimately, that's a question of fact, and that needs to be determined. And certainly by the time you get to the end of the process before the IRP, by the IRP. Direct discrimination can be conscious or unconscious. And so panels can ask, what is the reason for the PECs? If a disability was the reason for the PECs, or if it had a significant, that's more than minor or trivial, influence on the reason, that's sufficient to establish the necessary causal link. And note that a comparator may be actual or hypothetical. If we move on to the next slide, I'm asking you to consider what quite often happens in certainly head teachers' concerns as to what led to the permanent exclusion. And you quite often get the "we are a mainstream school" as a response. What that effectively means is the school can't meet the child's special educational needs. Now, of course, we all know that would be an unlawful decision if the reason for exclusion was a conclusion that the school cannot meet the child's special educational needs. But I venture to suggest that's also a direct discrimination. And I say that for two reasons, and I've set out there on this slide. I don't propose to take you through it word by word because I'm conscious of time, but I've set out the presumption in favour of mainstream education that's provided certainly for children with education, health and care plans under the Children and Families Act 2014. And the presumption effectively establishes that maintained mainstream is suitable or must be made suitable unless that results in incompatibility with the education of others, and that incompatibility cannot be removed by the taking of reasonable steps. And in the main, the taking of reasonable steps can be accomplished with the local authority providing additional resources to the school. And that's where we give rise to our presumption that actually the mainstream school can be made, should be made suitable, unless the statutory defences arise there. We go on to the next slide. Thanks, Ben. I have produced this slide on indirect discrimination, although I said I wasn't going to talk about indirect discrimination, but there we are. We've got the school applying a provision criterion or practice for all pupils, but that provision criterion or practice puts pupils with a protected characteristic at a disadvantage. So did the PCP place the pupil and others similarly disabled at a particular disadvantage when compared with non-disabled pupils in similar circumstances? And then the question to be asked under the Section 19 test is whether the school can show that the treatment is a proportionate means of achieving a legitimate aim, that I'm going to go into in a little bit more detail in a following slide. So Section 15, this is the one that essentially affects and concerns exclusion decisions most. And what needs to be established is unfavourable treatment. I've yet to find a decision that suggests exclusion is not unfavourable treatment. It clearly is. It's depriving a child of their education. The reason for the treatment is something connected with a disability. Needs to be shown the treatment can be objectively justified, and I'm going to come on to that. And of course, the school, the IRP, the local authority must have knowledge of the disability, and I'll touch upon that in a few moments. Your attention is drawn to the case of being another, the proprietor of St Dominic's Grammar School. This is a case that is actually an appeal from first tier tribunal discrimination decision before a tribunal judge, Holly Stout, who found in this case that the first tier tribunal had erred in law by failing to take into account expert evidence to the effect that B's SEMH, that's B's social, emotional, and mental health difficulties, could manifest in her lashing out at children, being easily aroused and becoming dysregulated. The other criticism was the FTT had failed to decide for itself objectively whether there was a causal relationship between the behaviour for which she is excluded and the disabilities. And the other criticism was the FTT perversely treated witnesses who gave evidence about factually what happened in each incident. It's a case that is worth reading from start to finish, but paragraph 44 there has set out the fact that the physical behaviour is conscious, deliberate, or even retaliatory doesn't of itself mean that it is not causally connected to the disability. Whether it is or is not is a question on which expert evidence about the nature of the disability in question is likely to assist. Moving on to the duty to make reasonable adjustments. The duty under Section 20 and 21 of the Equality Act is to take such steps as it is reasonable to have to take to avoid the substantial disadvantage to a disabled person caused by a PCP by the absence of an auxiliary aid or service or physical features. And your attention is drawn to another decision of Upper Tribunal Holly Stout, Upper Tribunal Judge Holly Stout, in the case of KTS and the governing body of a community primary school. Again, this is a decision worth reading from start to finish. At paragraph 31, in fact, she makes it clear, following Mr. Justice Linden's judgment in the Abrahart case, the duty to make reasonable adjustments can arise even if the claimant doesn't at the time identify what adjustment is required. And that's quite fundamental because that touches upon those children that don't have education, health and care plans, but clearly have special educational needs that may give rise to the behavioural difficulties that are the source of concern. In fact, all that is necessary is that by the time of the hearing, the claimant has set out their case as to adjustments, which they say ought to have been made. But bear in mind the fact that these adjustments may not have been identified at an earlier stage may be relevant to whether they are reasonable adjustments. Burden of proof is on the claimant under Section 136 of the Equality Act, but all the claimant has to show is provide some evidence of an apparently reasonable adjustment from which the tribunal could conclude the duty was breached, and then the burden passes to respondent to prove there was no breach. And in principle, it may be reasonable to take steps which merely reduce the disadvantage or have at least a real prospect of making a difference. And as the question of reasonableness is an objective one for the court, it's in principle irrelevant whether the respondent, and in this case that would be the responsible body, the school, thinks the step is reasonable or not. And then paragraph 33 of that judgment is there set out for you in the slide. The fact that some adjustments have already been made doesn't mean that the statutory duty does not require further or different adjustments. So the contended for adjustments before that makes the issue live needs to be evaluated and considered in its own right, and to whether the adjustments sought stand a real prospect of removing or further reducing the substantial disadvantage than the adjustments that may already be in place, whether alone or in combination. So it's important to identify whether there are other adjustments that would have assisted in removing or further reducing the substantial disadvantage. Moving on, so the duties of head teachers, this has already been touched upon by Ben under the Equality Act. The decision letter that the head teacher gives must advise the parents of the ability to make a claim under the Equality Act to the first tier tribunal. And of course, that has led a lot of people to consider that the IRP does not determine and therefore does not need to give proper consideration to the discrimination elements of any exclusion decision. That, of course, is the wrong conclusion. But of course, the IRP does not determine the actual whether or not discrimination has occurred. There's a link there for the further guidance for schools that we've already referred to, in fact. So the duties of the IRP, as I have said, where there's an allegation of discrimination, the first tier tribunal in schools is the appropriate body for determining it. It's not the duty of the panel to determine it, but it is an important consideration when assessing the lawfulness of the decision. We'll come on to the assessing of the decision very shortly. Next slide. The governing board's duties are to consider whether the decision to exclude the pupil was lawful, reasonable, and procedurally fair. And Ben has already touched upon that and has expressed that to be very much a review duty in the same way that the IRP is a reviewing duty. The role of the IRP then, review the governing body's decision not to reinstate, applying the civil standard of proof, looking at the evidence available at the time. Moving on, the principal grounds are the judicial review grounds: illegality, irrationality, otherwise known as unreasonableness, and procedural impropriety. Those three grounds are considered further in the next slides. The IRP must consider, and the governing body must consider, the IRP must consider whether the governing body outside of its legal powers. So illegality is whether there's been any infringement of a legal right. Education Act, Equality Act, Human Rights Act, Code of Practice, in fact, everything that Ben has touched upon. The next ground, irrational or unreasonable. The first bullet point there is if the governing board makes a decision so unreasonable that no governing body acting reasonably in such circumstances could have made it. You will, many of you will identify that as the Wensbury unreasonable test. The second bullet point touches upon the discussion that's been had in KP and Foreign Secretary and Home Secretary on an immigration decision, in actual fact. But that case beautifully, and I commend it to you, recommend it to you to read fully, and it's a very lucid and short judgment on the issue of rationality, and really differentiating between the Wensbury unreasonableness and rationality, which of course is outcome rationality. And the question is the outcome so unreasonable that no reasonable authority could ever come to it? But before we get there, what this judgment does is identify a process irrationality, and that reconciles the whether or not relevant materials were not taken into account or irrelevant material was taken into account. So process rationality includes the requirement that the decision maker must have regard to all mandatorily relevant considerations and no irrelevant ones. And in addition, the process of reasoning should contain no logical error or critical gap. Why that case is useful is it differentiates where the Wensbury unreasonableness very high threshold does come down to a lower threshold when looking at process irrationality and the failure to take into account relevant material. And then, of course, there's procedural impropriety. Moving on to the next slide as the third ground. Was the governing body's consideration so procedurally unfair or flawed that justice clearly was not done? I'm going to whistle through the next two slides, if I may. They're just examples of what may or may not offend procedural propriety or natural justice. So if we could, I leave those to you to consider in your own time. So the RP's duties on the issue of discrimination. So while the guidance says at section 213, rather limp-wristedly one might say, IRPs are not prevented from considering issues of discrimination. JR principles certainly include compliance with individual prohibitions on discrimination. And we say, as part of this webinar series, if an IRP fails to consider disability discrimination in a case that raises the issue, that may render the IRP's decision unlawful for failing to discharge the PSED, or irrational for failing to take into account the relevant considerations. Looking at those duties in detail, the questions are there set out for you when looking at section 15. That's the disability arising. Does the behaviour arise from a disability? The questions, first of all, is the pupil disabled? Did the school treat the pupil unfavourably? What was the reason for the unfavourable treatment? Was it arising in consequence of the pupil's disability? And it may not need to be the sole or main cause. It's sufficient for it to have a significant, more than trivial influence. Did the school know about the pupil's disability? Or could it reasonably have been expected to know? So it's not necessarily the school to know about the things arising, but did it have actual or implied knowledge of the disability? And if so, has the school shown that the permanent exclusion was a proportionate means of achieving a legitimate aim? In other words, was the treatment justified? The next slide goes into justification. What is the legitimate aim? What I've done there on this slide is set out potential legitimate aims: safeguarding of other pupils, maintenance of behavioural standards, consistent and fair application of a behavioural policy, confidence of parents, pupils and staff in the ability to maintain behavioural standards, requirement for the child or young person to develop strategies towards understanding the demands of behavioural standards. And the question that flows from that is, was the PECs rationally connected to the legitimate aim? But it's on the next slide that we really get into difficulties, or we get into normally contentious issues, and it's the proportionality. Was it a proportionate means? Was the PECs no more than necessary to achieve the legitimate aim? And could a proportionate alternative have been used without discriminating? Could something less discriminatory have been done instead? Did the school make reasonable adjustments? When balancing all the factors, is the impact on the pupil disproportionate to the likely benefits? What alternatives to exclusion were considered? And attention is drawn to part 4 of the guidance, factors considered before making a decision to exclude. So section 20, moving on to the next slide, this is the reasonable adjustments duty. And that may relate to factual matters that predate the PEC's decision, so prior behaviours, suspensions that have run up to the decision to permanently exclude. There are 3 separate duties within section 20 that we've touched upon: the PCP or general policy, the physical features that may disadvantage a disabled pupil, and the requirement to provide auxiliary aids. But the first is the PCP is by far the most common in permanent exclusion cases. So on the next slide, we look in detail of the questions to be asked. Was there a PCP? It may refer to a behavioural policy, for example. Did the PCP place the pupil at a substantial disadvantage? And that may be established if it is significantly harder for a pupil with a disability, particularly with regulatory disorder, to comply with behaviour requirements than for non-disabled pupils. And the comparison exercise under section 20 is a broad one. You're comparing the disadvantage to the disabled pupil with non-disabled pupils generally, rather than non-disabled pupils in materially similar circumstances, which you would do under the direct discrimination approach. Did the school know, or could it reasonably be expected to know, so this actual or implied knowledge, that the pupil had the disability and was likely to be placed at the substantial disadvantage? Moving to the next slide, please, Ben. You then ask, did the school take the steps as it's reasonable to have to take to avoid the disadvantage? And as we've seen in Upper Tribunal Judge Stout's decision, it's an objective, practical question focusing on what would have actually had a real prospect. The fact that a particular adjustment doesn't wholly remove the disadvantage doesn't mean it's not a reasonable adjustment. And the fact that some steps are taken doesn't mean that no further or different steps are required. That we have seen in the upper tribunal decision of Judge Holly Stout. Next slide, please, Ben. The IRP is assisted by the clerk, the SEN expert, the social worker, and the virtual school head. Let's looking at the role of the clerk on the next slide. We have to advise and assist the IRP with any questions regarding exclusion law or IRP procedure. Set out the other duties there, and of course, you may be aware that the clerk has the administrative duties of getting the hearing underway before the IRP. But the fact that the role of the clerk is to advise and assist may be, and we leave that to the question, an open question for you to consider, may be the quid pro quo for the fact that the IRP, unlike the first tier tribunal, although it is being called upon to consider suggestions of discriminatory practice and findings of discrimination, not actually determinations, but certainly conclusions on discrimination, the IRP is not legally qualified. And it may be that the clerk provides the safeguard for what has, over the years, over the decades, become a much more technical analysis that is required when determining whether discrimination has occurred. The next slide, the SEN expert. Of course, given that we've considered causation and whether or not the behaviours that for which the exclusion has been given are linked to special educational needs, you might consider the SEN expert is vital. But the SEN expert's role is not to assess the pupil's SEN, and it's particularly limited in that respect. If we move to the next slide, we actually see the guidance on the SEN expert's role. And it's really on whether the school's policies which relate to SEN or the application of these policies in relation to the parent excluded pupil are lawful, reasonable, and procedurally fair. But paragraph 234 there, you say the SEN expert should advise whether they believe the school acted in a legal, reasonable, and procedural fair way with respect to the identification of any SEN that the pupil may potentially have, and any contribution that this could make to the circumstance of the pupil's permanent exclusion. I've underlined that because there are on many occasions SEN experts who say their role is not to trespass on the individual circumstances, but in fact, paragraph 234 there does require something of the SEN expert to consider the school's approach to identifying any SEN that the pupil may potentially have. Albeit, paragraph 235, you see there, the SEN expert shouldn't criticise the school's policies or actions. And then we have on the next slide the role of the social worker. And again, I've underlined in the guidance there what the social worker, if one is appointed, can assist the panel with on the contribution that the pupil's needs could have made to the circumstances of the pupil's permanent exclusion. And the same is said of the virtual schools head in the case of looked after children, advising the panel on the contribution that pupils' needs could have made to the circumstance of the pupil's permanent exclusion. Again, if both of those people are relevant to the exclusion in question, then their advice is obviously going to be relevant information to take on board when determining the lawfulness or otherwise of the exclusion generally. So that's it. I'm conscious that I have whistled through my slides, but I'm just looking at the time. That is the end. We do have time for more questions. I see only one question, which isn't a question, it's a thank you to us, which is very kind of you. And thank you for that. Here we go. When considering a potential Section 15 claim, if I understand correctly, the disability does not need the sole or main cause of behaviour, that's right, nor to constitute something arising in consequence. Behaviour can also constitute something arising in consequence, even if it is conscious, deliberate, and or retaliatory. With this wide net, would it be correct to say it's quite difficult for a respondent to argue that the improvement did not arise in consequence of disability? Absolutely. I totally agree with that. It is difficult for a responsible body to say that the impugned behaviour did not arise in consequence of a disability or a special educational needs that's capable of being a disability, but not impossible. And of course, each case will turn on its own facts. But yes, most of the exclusion decisions and the discrimination decisions will turn on the justification for unfavourable treatment under the Section 15 test and whether there's been any failing to make reasonable adjustments that have been identified at that stage. I don't know, Ben, if you had anything to add to my answer that I've just given there.
Not really, other than so this came up in a question that I answered silently during Lachlan's presentation, which was around how the question of objective causation works under Section 15. And essentially, there are 2 points at which causation arises. Firstly, the question of whether there is a causal link between the disability relied upon and the thing arising in consequence of the disability relied upon. And I mean, the guidance, at least from the employment sphere, tends to suggest that some medical or professional evidence is required in relation to things arising from, let's broadly say, neurodiverse conditions and or mental health type conditions. Obviously, if the thing arising is, a wheelchair for somebody who is paraplegic or similar, then that's obvious. You don't particularly need an expert's report to tell you that that arises from the disability. But in relation to neurodiversity, that link needs to be established through evidence. And then the next causation question is the question of whether the unfavourable treatment, so the PECs or the suspension, was because of the thing arising in consequence. So it's that those 2 points are how causation arises. I'm just conscious that we've had, I think, a small flurry of a further query on.
And I've had the ability to read that next one.
Yeah.
Thank you, Ben. You've answered that first one in the list. If the IRP has no duty to assess if there's been a breach, does it render their decision unlawful if the IRP does make a finding of a breach, or is it in its powers to make a finding of a breach? It's not making a determination of a breach, but what it is considering is whether there has been breaches, and it is not unlawful if it makes findings that suggest a breach. But of course, that finding does not bind the first-tier tribunal. So it is not a finding of discrimination against the school. It is a finding that the requirement for lawfulness may have been breached because it's identified certain failings in either the justification for the exclusion under Section 15 or the failure to make reasonable adjustments under Section 20. Ben, I don't know if you wanted to add any more to that.
Yeah, I'll come in. It's a really central question. Thank you for raising it. And I think the key here is there is a technical distinction between those bodies who are charged under the Equality Act 2010 with the determination of a claim or an appeal based on a breach of the Equality Act, i.e. the first-tier tribunal, i.e. the county court, and the role of the IRP, which is, I suppose, could be described as an extra statutory role in relation to the Equalities Act, because what the IRP is doing clearly is reviewing on judicial review principles, lawfulness, reasonableness, and procedural fairness, reviewing the decision of the GDC at stage 2. And part and parcel of judicial review principles is that question of compliance with the Equality Act 2010, with compliance with the Human Rights Act 1998, and of course the other statutory provisions that are brought to bear under the question of PECs. So I suppose my answer is that an IRP that makes a finding in relation to a breach of the Equality Act is simply discharging its function in that broader sense of applying judicial review principles and considering the matter through the lens of the Equality Act 2010. So I don't think they step outside of their role by doing that. But as Lachlan has pointed out, the first tier tribunal, the county court, has a separate role and entirely enjoy that jurisdiction to themselves in addition to whatever findings the IRP might make.
Thank you, Ben. There's yes, so we've just had a question come in about would it be possible to copy the slides? You will have those either sent to you, but they will certainly also be available on the link that broadcasts this this webinar that is available to you, so no problem there. One question that is a bit of a how long is a piece of string question, Ben. A lot of legal issues for a lay panel to consider. How long on average do you think an IRP hearing should last to cover all issues? Well, it shouldn't last more than a day, but it shouldn't last less than a day, because you're absolutely right. But it will always turn on its own facts. I don't know if you have any different opinion, Ben.
There are a lot of legal issues for a lay panel to consider. I fully agree with that. And you can see on the slides that we've got on the screen, that was one of our preoccupying queries that we came into this webinar with. How realistic is it to expect the IRP to get through all of these technical knotty matters that we've been talking about, and which lots of lawyers can come a cropper on, in addition to judges as well, because they are so technical. How long should it be at the IRP stage? Long enough, I think, is it needs to cover the issues. There needs to be time for reflection. And in some of the case law that we've been talking about, particularly the ones regarding Article 4, child criminal exploitation, some of them were particularly complex cases and went over a day, and also had adjournments and breaks throughout because of the complexity of the issues, the volume of the material. So it really is, you have to cut the cloth to suit the particular case, I think. But yes, I fully acknowledge the concern. And I think, Lachlan, we might have had I think we had a stray question in the webinar chat button, which we can entertain, notwithstanding how it's come to us. And it's a question of how do you think this area will be impacted should, as mooted by various political parties, the ECHR be abolished? Very broad question, probably a question for a whole another webinar, frankly, or even a series. And I've not yet gotten around to reading Lord Wolfson's report that has apparently been reported on in the press this morning, around, I think, a legal analysis of how the UK can and why it should leave the ECHR from a Conservative Party perspective. Clearly, this is a rather live debate, lots of speculation attached to it. How would it practically affect PEC's decisions and challenges? Well, I think that probably what one can say at this stage is that it would necessarily limit the range of remedies available for claimants seeking to challenge such decisions on the basis of some infringement of rights. And it would essentially leave the statutory framework, which would include the Modern Slavery Act. So there's some statutory protection that remains in the cases of child criminal exploitation cases, but in all other respects, the common law would have to be relied upon. So there are broadly analogous common law rights in relation to some articles of the ECHR, but perhaps not all of them to the same extent as currently legislated for. So I think it would lead to a slight narrowing, possibly significant narrowing in terms of available remedies. Lachlan, I don't know if you had a final thought on that.
No, I totally agree. I mean, it's so easy to say, isn't it, that in the vast majority of the IRPs considering PECs it probably will not make much difference because of the protections that's available under the domestic legislation. But that is the thin end of the wedge and the start of the rot, to mix my metaphors terribly. Because, of course, what you do when you deprive litigants of other avenues to consider is you narrow the issues, and you may be narrowing the issues in such a way as to steer scrutiny away from the real mischief. So, as Ben says, this is an enormous topic and one that does require considerable time for discussion. But I think generally it will amount to a narrowing of issues. Will it make much difference to most of the exclusion decisions? Maybe not, but I don't think that is an argument for necessarily taking away protections that might otherwise have been afforded. But if we be best to leave it there. Now, I'm going to draw the webinar to a close, unless, Ben, there is anything else you wanted to add.
No, please go ahead.
We have overrun. I do apologise for that. I am very conscious that your time is limited when you attend these webinars. Thank you for all those who have stayed and to the bitter end. We're very grateful for that. We're very grateful to your engagement, and we are grateful to you also for the tremendously helpful questions that you have asked in order to steer the discussion into somewhere that's useful and meaningful for you. So thank you for that. I'll repeat what Ben said at the beginning. Don't forget the third webinar in this series on the 19th of November. Avoiding and defending judicial review. Please do try and attend that. And have a look also on our website about the education conference on the 5th of February next year. It's on our website under Events Education Law Conference 2026. You are welcome to join us for that as well. The registration for that details will be on the website. Thank you, all of you. Thank you, Ben. Thank you, all of you, and thank you, Delphine, in the background for making this go so smoothly. Bye-bye all.